in their infinite wisdom, as did many other state legislatures, decided, all right, we recognize that there's some problems with the partnership. We're going to create a statutory business form that improves upon the partnership and gives the partnership some of those same protections that exist in LLCs and in corporations. By that, we are going to create a limited liability partnership. A limited liability partnership is an improvement, so to speak, upon your traditional partnership. In an LLP, which is a statutory business form, the partners in the partnership are not personally liable to each other. Okay, it gets rid of that whole joint and several liability problem. Who is responsible now? If the partners are not individually responsible for the debts and the obligations and liabilities of the business, who is?
Entity.
The entity, right. Why? Because somebody's got to hold the pot, right? We already said the owners wouldn't, so the entity must. That is why, in a statutory business form like this, the state of Florida requires that statutorily established business forms like this have insurance. Because how easy would it be, I sound a little bit like I'm going on the dark side to say this, but to basically divest an entity of any kind of assets so that it wasn't liquid in any form and didn't have the ability to pay for that tractor trailer accident on I-75, right? Okay, that's why these entities to exist must have liability insurance requirement by the state of Florida, so that there is a pot of gold. Okay, somebody's holding the bag, and in this case, it's going to be the entity. Of course, that entity has to pay those insurance premiums, obviously. Okay, so that's basically the protection that exists with that LLP business form. So, does that make sense to everybody? Okay. Now, a limited partnership is a little bit different. In a limited partnership is one where you have one partner that is a limited partner that is not personally liable for the debts and obligations of the business, but all the other partners in the limited partnership are. The limited partner by themselves it's usually, that's your classic silent partner example, where one limited partner contributes financially to the business, but does not get involved in the business on any level. As a matter of fact, if a limited partner does get involved, starts making management decisions, starts getting involved in operations, things like that, that limited partner can lose that protection that they have and can indeed be deemed a partner that is jointly and severally liable just like all the others. That's why I kind of think of this as a little bit, that's why I put this here, okay? Because a limited partnership is a little bit of an advanced form, a little bit more of a complex form of a regular partnership, because now we have a limited partner that is indeed protected. Generally speaking, their liability is going to be limited up to the extent of their investment. So if they invested 10% in the business, their liability will be limited to 10%. I think it's generally how that's structured. But all the other partners are just the same, treated just the same as in a regular partnership. That makes sense with limited partnership. All right, but this is still problematic, right? Because the limited partner is protected, which is lovely, but what about all the other partners? They're partners just like a regular partnership. They're still jointly and severally liable for the acts of each other. Yeah, no better for them. How do we improve that? We improve that by the limited liability and limited partnership. That, in many respects, is just an outgrowth of this. Okay? Now, everybody, the limited partner and all the other partners in the partnerships have that limitation upon their liability. And it is the LLP itself that is the entity that is responsible, and of course the entity that must have insurance under the state of Florida's requirements. So again, that kind of improves upon the limited liability, the limited partnership form. Any questions?
Did you say limited liability, limited partnership?
Yes.
Okay.
Exactly. Limited liability, limited partnership.
people lose the LP status? Does that usually happen because something's gone wrong and something's being evaluated like in court at that point?
Yeah, so
like how do they know somebody like that silent partner got involved and started making business decisions? Like how does that happen?
I mean, that would involve, that would be a process of discovery of there being some dispute within the partnership. Proof, evidence that limited partner was engaging in business.
Okay. And then
operational decisions.
They're then liable.
Exactly.
Okay.
Exactly. Yeah. Discovery depositions, memos, an email saying, I don't think that we should run the business this way. I think you should be doing it that way. One email like that might be enough to sink a limited partner. So, any questions about that? Okay. All right, so we talked about that, a requirement of insurance. All right, I think we can move on to corporations then, unless anybody has. So I would encourage you to kind of commit this to memory, commit my little formula to memory, because hopefully that'll help you understand the distinctions between those. Okay, so let's move on to corporations. Two big types of corporations that I want you generally to be aware of. C corporations and S corporations. C corporations are your traditional corporate form. When I say the word corporation, what do you think? What comes to mind? Name a corporation that comes to mind. IBM, Walmart,
Coca-Cola.
Coca-Cola. Think you've named 3 Fortune 500 corporations. According to an analysis of corporate filings, the vast majority of corporations in the United States are small family-owned businesses. Okay. It's very easy to think of, when we think of corporations, we do think, that's your gut reaction to think big, Fortune 500, multi-billion-dollar capitalization, all that. But really, most corporations in the United States are actually small business forms. What is one of the advantages of a corporation? Limited liability, absolutely. Limited liability, because who is liable? The corporate entity, right. One of the biggest reasons, I think, corporations were really one of the first existing business entities, kind of beyond this partnership structure, that allowed what is known, what I refer to as fractional ownership. Who owns a corporation? Shareholders, stockholders, shareholders, exactly. Okay. A corporation has the ability to sell off pieces of itself. When you are a shareholder in a corporation, you own a certain percentage of that corporation. Many family-owned businesses might have 100 shares. Okay. 3 owners, they each own, well, let's say 2 owners and say they each own 50 shares. Okay, as simple as that. Heck, you could even say that there's 10 shares and they each own 5. I mean, it can be structured in all kinds of different ways. How many of you have retirement accounts or pension accounts through work? Okay. Somebody in this room owns 0.0000001% of Walmart. Right? Okay. I guarantee you, if you have some S&P 500 index fund in one of your funds, which you probably do, because that's kind of a pretty basic thing, common thing to have in a 401k or pension fund. You own a tiny, tiny infinitesimal portion of one of those entities. Those entities are able to sell off portions of themselves to raise money, basically. And that's, again, one of the biggest benefits or advantages of a corporation. That's something that partnerships cannot do. Partnerships can't sell off part of themselves in order to raise money, but corporations can. Now, how can you tell how much a corporation is worth? That was a loaded question that was intended to be difficult, so I'm going to unpack that a little bit.
Is it like how many shareholding parts times how much it worth?
Yes.
The ownership?
When we're talking about a publicly traded corporation, yes, that is the basic formula, okay? With a publicly traded corporation, it's relatively easy to say how much a company is worth. Why? You multiply what that share price is selling at today at the close of business times the number of shares. Multiply those two numbers together, that gives you a rough estimate of what the value of the corporation is. That is why when bad news strikes a corporation and the share price plummets, the value of the corporation plummets because the share price is no longer what it is. And the share price of a corporation that's publicly traded is what it is trading at the end of the day, that day. Okay? Whether it is $500 a share or $2 a share. That's how, and my corporate finance teacher in law school is probably rolling in his grave that is my definition of how you define and assess corporate value. But I don't want any of y'all to kill me, so we're just gonna leave it there. The assessment of, and I like my explanation of it better than his. The assessment, though, of how much a privately held corporation is valued at is significantly harder. Why? There's no bell ringing at the end of the day that says how much that share value is. It's not publicly traded, it's privately held. Again, this is how the vast majority of corporations in the United States are held, are privately held corporations. The only way that you can tell the value of a privately held corporation is by an in-depth process of due diligence that is assessing all of the corporation's assets, liabilities, accounts payable, accounts receivable, debts, obligation, and on and on and on and on, to determine all of the company's assets, all of the company's liabilities, and then you have the intangible variable of future growth. Yeah, I mean, we could go on and on depending on what type of business we're talking about. But so determining the financial value of a privately held corporation is a significantly more difficult proposition. Going back to publicly traded corporations for a minute. I, generally speaking, categorize corporations as owned usually by 3 different groups. And so I want you to understand what the 3 different groups are that are the most common shareholders of publicly traded corporations. Most shareholders are mutual funds, institutional investors, and individuals. Mutual funds, institutional investors, and individuals. If you were to go pull up any Fortune 500 company, you can get a detail of this. I think the Wall Street Journal publishes it online. You'll get a list of who the major shareholders are by percentage of any one of the corporations. And what you'll generally speaking see, like for example, I think Walmart is still majority owned by the family, by the Walton family, I think. So what you would see for Walmart is you would see Walmart under the percentages. Let's just go with it hypothetically that it is held privately, or that there still is majority familial ownership. 30% is owned by Walton Family Trusts or something similar. Okay, that's the kids, the grandkids, the great-grandkids. Okay, but then you'll start to see multiple percentages underneath. Vanguard, 2%. T. Rowe Price, this fund, that fund, 3%. On and on and on. Multiple different mutual funds that will own various different percentage shares that they have in their mutual funds. And it's those mutual funds that you have in your 401ks and your pension, I guess not in your pensions, but 401ks, 403bs. That's how y'all are the owners of a lot of those types of corporations. And then finally, you'll see individual investors. That won't be listed on, you won't see names like on Wall Street Journal, but but they'll have a category for, and those are people who are buying shares of Walmart on Ameritrade or something like that. Okay, so those are basically the 3 categories of institutional investors are generally things like insurance companies, okay, that purchase or private equity, things like that are purchasing large chunks of a business for ownership purposes, okay? Mutual funds, institutional investors, and individuals. Any question about ownership from that perspective on corporations? Okay.
I think I missed something.
Sure.
You started with two types, you said C corps, what was the other one?
Oh, S corps,
Sorry.
but we haven't gotten to them yet. Yes, yeah. All right, so you did miss it.
Okay.
All right, these owners, these shareholders, are they personally liable for the debts and obligations of the business? No, absolutely not. Okay, the example that I always give. If you own shares of Volkswagen, did somebody come knocking on your door when they were hit with, $50 billion in fines and in lawsuits and everything else like that for emissions problems? Did somebody come knocking on your door and say, hey, contribute to this VW lawsuit losses? No, right? You as an owner are not personally liable for that business entity's liabilities. In the same way that now, if you're a partner in VW, yes, you would have that, but as a shareholder, you don't. However, what financial consequence did you face? The loss of the share price.
I got the foreman to know about that.
And you might have, if you owned the car, you might have had, loss of value of your vehicle. There's actually plaintiffs' attorneys firms that are actually now focusing on diminution of value claims for VWs on resale, and lawsuits they're going to be filing against Volkswagen for again diminution of value on resale because of those emissions problems, which is so maybe that's a profit source. I don't know. Anyway. You did sustain a little bit of a financial impact because the value of the share that you own of Volkswagen is not worth what it had been, probably, when you bought it, because of the acts. But again, that's a risk that you take in buying shares and investing in a corporation, okay? Similarly, officers and directors of a corporation are generally not personally liable. Officers and directors are generally your officers are going to be your CEO, CFO, on and on. Your C-suite folks that are in those management and executive positions, they're generally not going to be personally liable.
They're not financially personally liable, but in the event that people are injured, could they be criminally held liable for if they could prove that they knew about certain things?
That becomes a lot. It becomes a lot harder to prove. Then you actually have to. What you have to prove in that situation is that they had criminal intent to harm, and that can be that. That's not to say that it can't be proven.
Is that even possible?
Oh, you look at Bernie Madoff.
Oh well, that's
right. That was absolutely an intent to defraud. A business schematic which was designed with intent to defraud, and that, yes, he faced criminal liability for that. But making a bad business decision, failure to oversight your emissions engineers, is that criminal intent? Personally, I don't think so. I think it's bad business, bad management, perhaps a breach of a fiduciary duty of care from a corporate litigation standpoint, but not criminal. It's just my opinion on that. I'm sure others would disagree, but so generally speaking, the entity itself is not liable. However, there is an exception, and that is if the aggrieved party is able to prove that a corporation was formed with the intent to defraud, in which case the corporate veil can be pierced. Okay? That's the Bernie Madoff situation. That's a situation where now that was a whole trading situation. I don't even know if he was actually formed as a corporation, but if the intent of the business is to engage in a fraudulent activity, in that situation, then the shareholders can be found personally liable. That is different than the corporation engaging in fraud. Does that make sense? It's unfortunate, but a reality of the business world that business employees engage in fraud all the time. I hate